so we are going to get started, and I'm going to ask the state to please call our next witness.
Thank you, Your Honor. The state we call Deputy Brian Polito.
Deputy Polito. Deputy Polito, good morning and welcome. You'll come forward to be sworn as a witness. Wherever you're comfortable, if you'll face me and raise your right hand, please. Perfect. Thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. If you'll follow the bailiff now to the ramp that leads up to the witness chair, please watch your step. When you get to that chair, go ahead, have a seat, make yourself comfortable. That microphone is fully adjustable. You may proceed, Mr. Dirks.
Thank you, Your Honor. Good morning, Deputy. Please introduce yourself to the jury.
My name is Brian Polito. I'm a canine handler and trainer with the Hillsborough County Sheriff's Office.
All right, how long have you been with the Sheriff's Office?
I'm in my 22nd year full-time.
Of that time, how long have you been a canine handler?
Since 2013, so what, 8 years now? 9 years?
Most of us probably understand what a canine handler is, but why don't you go ahead and explain it to all of us so that we're clear on that.
I'm assigned actually 2 dogs. I've got my patrol dog, and then I have my bloodhound. We respond to all calls with my patrol dog, felony in progress stuff to track people. We do article searches. He's also a narcotics dog. Champ, the bloodhound, is strictly a scent-specific tracking dog. And when he finds somebody, he doesn't bite them. It's just to find them. I also help out and assist with training the new handlers and the new dogs.
All right, I want to find out a little bit about the training of specifically Champ, your bloodhound.
Yes, sir.
Tell us about the process of training Champ to be able to do what Champ does.
When I received Champ, he was 16 months old. He was a house dog. Got him from a rescue. When I got Champ, we started training him just like we train all the dogs as far as tracking, except for he is scent specific. So we track him, we train them to track specifically a certain scent, not the freshest odor like the patrol dogs do. We just start out with short tracks with an odor. Whoever is going to be running the track for us, we get them to put a towel or something underneath their shirt where they get good and sweaty and smelly. And it's just very short tracks, and then you just work up to longer tracks. That's what we did here at the Sheriff's Office. And then I apologize, I don't remember, probably 8 months after I got Champ, I went to Tallahassee, and the Jimmy Rice Foundation puts on a school, a tracking school up there, and I went through that. It was a week-long school with other trainers from all over, civilian search and rescue trainers and other law enforcement.
And so Champ was with you during that experience?
Oh, yes, sir. Yes, sir. Yeah. Yep.
All right. You've told us about the experience you had with Champ, and you told us about how Champ worked up with a specific scent. So then you were able to, I presume, then you were able to corroborate or verify that Champ was able to do what you were wanting Champ to do. Is that right?
Yes, sir.
All right. Since you, does Champ live with you?
Yes, sir.
Since Champ has been on duty, can you give us any estimation as to how many different times Champ has been asked to follow a specific scent?
For a call or call and training combined?
Let's talk about calls.
Okay, for calls, we've had at least 100 deployments. Yeah.
And when you have those deployments or in the training, is there some way that you can observe Champ to determine whether or not Champ is on the scent of a specific scent?
It's a good guess. Yes, I mean he does have some signs that he shows, and the main one is his tail. When his tail is up and high, he's tracking. There's no doubt he's tracking. As his tail gets down lower, once he gets about straight to below, usually he'll just stop at that point and let me know. So I'm, yeah.
All right. All right, so you've told us now that Champ, as opposed to your other dog, is scent specific.
Yes, sir.
So if I understand what you're telling me, there is a specific identifiable scent that you put Champ on and ask Champ to follow that scent if there's a follow.
Yes, sir. So like, example, if you went missing, I like shoes. Shoes have a lot of odor to them, obviously. I would get that shoe from you. Hopefully no one else has touched it. If they have, then I would hopefully have that person there so that I could eliminate them. I would let Champ smell them. I put that article inside of a bag. Sometimes if it's just been left there, we just leave it there. Let him walk around and do his business to relax a little bit for 3 or 4 minutes whenever I get there, and then I present that article to him. So he's getting that scent is what I'm looking for, and then send him on his way.
All right, you mentioned that you let him relax and do his business, whatever that is. That's a routine that Champ follows?
Yes, sir. Yeah.
All right. With that background, I want to take you back to the early morning hours of May 28th, 2022. Were you asked to assist fellow deputies along with Champ in an attempt to follow a scent in the area around Lithia Pinecrest, somewhere around Kite Ridge?
Yes, sir.
All right, tell us about that. Tell us what information or articles you were provided. Walk us through the process after you received that request.
When I got there, I met with a lieutenant over at the scene who advised me that out on Lithia Pinecrest Road, someone, and I don't know who, but there was a drop of blood found, so that's where they needed me to go and start at. So I drove around Lithia Pinecrest, got out there, met with the deputy there who advised where the blood was at. I believe crime scene come over right after that and took a portion of that, whatever they did, but they did leave me enough on the leaf that I could still see it. I retrieved Champ. I let him walk around and do his business for a minute, walked him up, put his nose down by the leaf, and told him to check, which is what I always do whenever I'm giving him the scent article. His word is check. I'm asking him to smell it, and and then find him is the command to. All right, let's go find that scent.
And do you mentioned that there was a leaf involved. Do you remember that maybe there was some sort of a business card or some other article there which identified the specific leaf that you were going to be working
Yes, sir.
with?
I believe it was a business card. It was a small piece of paper. I believe it was a business card, though.
All right. Then you went through the process. Champ did his business, and you told Champ to check. Did Champ react to that scent in any way?
Yes, sir. He started to go, when I presented it to him, the leaf was in the ditch. There's a wood line, a lot of brush facing it. Obviously don't know which way the person who had the odor is gone, so I faced him towards the wood line, presented the blood leaf to him. He made a right-hand turn, went, I don't know, 5-10 feet, turned around and started heading east. East on Lithia Pinecrest.
And as Champ went down Lithia Pinecrest, did Champ follow a straight line? Was there any deviation? Do you recall anything about that?
He did. He was steady, straight on it, tail up. At one point, he did go up towards Lithia Pinecrest. I believe, I can't remember it without seeing it again, but I believe he made a left turn and then just a circle and then came right back down to the ditch line and ran back east again, continued back east again.
All right, so then you described that there was a turn involved. Is there any way for you to determine, based upon your experience with Champ, what could have caused that deviation or that turn?
Either the person went up that way to the road and then came back down, or we're alongside the road, you've got your trees, it's a ditch with vehicles going by, you've got wind from those vehicles. Odors are very light, obviously, and that wind could be moving that odor around. It could be coming off of the wood line, pushing back up with vehicles going by. It could be sucking that wind back up there. Maybe at that point is where he just got it and he came up to the fringe of the odor and came back down. Or again, like I said, maybe the person went up to the road and then when they came back, that's why he came back down.
Okay, so you described Champ going down the ditch along Lithia Pinecrest.
Yes, sir.
Do you recall approximately how far Champ went along that general path before doing anything different?
Before he went up to the road or just okay,
the entire path? Tell us about
the
that.
entire, maybe 50, 60 yards.
Okay,
Yeah.
and after those 60 yards or so, 50, 60 yards, what happened?
He cut up into the wood line, maybe 15 feet or so as I was behind him, because I usually run with a 21-foot lead, and I probably had 15 feet out on that tracking lead. When he cut up into the wood line there, I was probably about, like I said, 15 feet behind him, and then that's whenever I saw what I believe to be blood all on the side of a tree. It'd be on the west side of the tree. At that point, I held Champ up and didn't let him go any further. He was kind of out of my sight and then came back into my sight because he was already up in the woods about 15 feet from me. I pulled him back out at that point.
And why did you pull Champ out at that point?
With that amount of what I believe to be blood there, and then the other canine handler that was running with me, he found another spot of blood, we believe to be blood, on the other side of the tree, be on the east side of the tree. With that amount, I felt pretty certain that the person that was losing that blood was nearby. Champ is not an apprehension dog. Champ has no way to defend himself, and I don't send him in on somebody who might be armed or who's going to hurt him or anything like that, so I stopped him, pulled him out, and Deputy Hall was following in his patrol vehicle, which he's also a canine handler. I pulled Champ out and asked Kalen, Deputy Hall, at that point if he would get his patrol dog, which is an apprehension dog, and come down and let him finish from that point on, and obviously unless we got something different that we needed the bloodhound for again.
Okay, so just to be clear, when you went out to that scene or sometime thereafter, another canine handler was also at the scene, is that correct?
Yes, sir. There was three of us. Deputy Hall and Deputy Caban, who was actually walking with me and found the blood on the other side.
So the decision was made first to deploy Champ before any other dog?
Yes, sir. Yeah.
All right. After you explained to us that after you pulled Champ back after making the observations, and first of all, can you give us an idea of the general proximity of those suspected red spots or blood in relation to the woods, the tree line that you're talking about?
The tree that I saw was right at the edge, maybe 8 to 10 feet in. Not far. It was right at the edge is where that tree was at.
Were there other deputies in addition to the canine handlers which are also in that same area while you were doing your work?
Yes, sir. There was one other deputy, and I apologize, I don't remember his name, but he was there. There was another patrol unit there.
All right, and we're at the point now where you pull Champ back.
Mm-hmm.
You're not going to let Champ in that area, in the wooded area. Do you recall whether there was any police radio traffic or communication with any other aspects or parts of the Hillsborough County Sheriff's Office investigative team that reacted and was participating in the investigation at that point?
At that point, I believe I'm the one who initiated it. I'd have to listen to it again, but I called aviation to come over and check that wood line to see if they had any hot spots, if they could see anything in there. Obviously, before we go sending our people in or sending the dogs in, just to give us a heads up. And they advised when they got there that they saw a small heat signature just inside the wood line from where I was standing at, which, guesstimation probably 40, 50 feet from where I was standing.
Okay. All right, so you're talking about a heat signature, and I'll get into another deputy with that, but it's your understanding that the Air Service is equipped with equipment that could possibly assist in identifying heat areas.
Yes, sir, absolutely.
All right, and do you recall whether or not Air Service complied or answered that request?
Yes, sir, they did. Like I said, they notified us that they saw a small hot spot there. They couldn't, from what I remember, they couldn't identify it, but it's very heavily wooded right there, a lot of bushes, so I'm sure that inhibits them a little bit. But
Deputy Hall's dog then took over, is that correct?
yes, sir. I put Champ away, and then Deputy Hall got curfew out.
Do you recall whether anyone was apprehended in the vicinity of that area of the suspected hotspot?
Yes, sir. I did not go in to the woods with them. I stayed on the outside in the ditch line. I believe it was Deputy Caban and Deputy Hall that went in there. I don't remember if the other deputy went in with them or not. They weren't in the wood line for 30 seconds, and they made contact with someone who was laying in the grass inside that wood line.
So were you there when that happened?
I was outside. I wasn't there to see it when it happened, but I was 30, 40 feet away.
At some point, were you close enough to identify the person that was apprehended from those?
When I was standing there, they walked this person out, and that's whenever I first observed them. Yes.
And can you identify that person?
Yes, sir.
Is the person that was apprehended in the courtroom today?
Yes, sir. I believe so.
Okay. Would you point to him and describe his location or his clothing so that we can all be clear as to who you're referring to?
There's 3 people that are facing me at that desk. He's the one in the center.
With the dark rimmed glasses?
Yes, with the dark rimmed glasses, white shirt, blue tie.
Your Honor, may the record reflect that Deputy Polito has identified the defendant.
The record shall so reflect.
Thank you, Your Honor. All right, we're at the point where the apprehension. Did you play any other part in this investigation?
No, sir, I did not.
Was your deputy's uniform equipped with a recording device, that is a video recording device where it recorded what was going on during the relevant times of this investigation?
Yes, sir. Right there, and it was in that exact same spot on this exact same vest.
Okay. And have you had an opportunity to review the recording of the relevant portions of that work that you and Champ did leading up to the apprehension of the defendant before coming in here to court today?
Yes, sir.
And does that video recording regarding those relevant portions fairly and accurately depict what happened on the early morning hours of May 28th, 2022?
Yes, sir.
All right, let me show you what has been marked as exhibit number 23. Take a look at number 23 and any markings on 23 and tell me if you can identify it.
Yes, sir. That's the one I launched.
And is that the video of what occurred on the morning of May 28, 2022 that you testified about?
Yes, sir.
The state office is at number 23.
Any objection?
No objection.
23 will be admitted.
Your Honor, may we publish this video?
You may publish.
Thank you.
No. Didn't do anything that caused you any concern when they were leaving that something physical might occur?
No.
In fact, on the way home, when you get the call from Kay, you tell him, cut it out, and you hear him in the back go, okay, right?
Correct.
You don't hear him screaming at her?
No.
You don't hear him cursing at her?
No.
He's not cursing at you, saying, Kelly, stay out of this is none of your business?
No.
He just says, okay.
Correct.
And then when you get the message from Kay, the last thing is that it's all good now, right?
Correct.
And you're close enough with them that you say, tell him to stop or I'm going to kick him in the balls, right?
Correct.
No reason to think anything would get physical, right?
No.
Could I just have a moment?
Yes.
Nothing further.
Redirect.
There was that end moment there that we got to watch about 11:30. Mr. Terry took a drink, then he hugs your husband goodbye, and he's having a conversation with you and your husband. Describe his level of intoxication at that point.
He was intoxicated. I could tell by his his eyes and the way he was slurring his words.
All right. You could hear him slurring words.
Yes.
You could see what about his eyes?
They just looked glossy and a little closed.
All right. And again, I'm not suggesting you're any kind of expert, but in just your everyday experience of dealing with people who've ever been intoxicated, did you believe the defendant was intoxicated at that point?
Objection, relevance outside the scope, beyond your expertise.
I'll allow her to offer her lay opinion as to beyond the scope. I'll allow you to cross.
I do, yes.
Thank you, ma'am.
Just to be fair, you had been drinking that night too.
Correct.
You had actually been drinking before you even got to the landings, right?
Correct.
And so had Kay, right?
Correct.
And Kay was intoxicated too, right?
At the beginning, yes.
Okay. So the whole group was drinking, not just Mr. Terry, right?
Correct.
Thank you. Nothing further.
Eddie, redirect.
When Kay left, did you think that Kay was as intoxicated as the defendant?
No, I did not.
Thank you, ma'am.
Release or subject to recall?
She is subject to recall.
Okay, ma'am, you may step down, but you are subject to recall. So I don't know if they want you to wait outside or not.
No, she's free to go.
Free to go for today, but you may be recalled. Thank you.
Thank you.
I'll ask the state to go ahead and call your next witness,
State call Sean Andrews.
Sean Andrews. Mr. Andrews, good afternoon and welcome, sir.
Good afternoon.
You'll come forward to be sworn wherever you're comfortable. If you'll face me and raise your right hand, please. Thank you. Do you swear affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth? So help you God?
Yes, I do.
Thank you, sir. If you'll follow the bailiff now to the ramp that leads up to the witness chair, please watch your step. When you get to that chair, go ahead, have a seat, make yourself comfortable. That microphone in front of you is fully adjustable. All right, thank you. You may proceed.
Thank you, Your Honor. Afternoon, sir. If you would, introduce yourself to the jury.
Hello, I am Sean Andrews.
And Mr. Andrews, are you the husband of Kelly Andrews,
Yes, sir.
the woman that just walked out of the courtroom?
That's her.
Okay. I want to talk with you about Kay Baker. Do you know Kay Baker?
I do.
And how did you first come to meet or know Kay Baker?
I met Kay roughly 10 to 12 years ago. Friends of my wife, Kelly.
All right. And friends of your wife eventually ended up becoming your friend.
Yep, absolutely.
All right. And so throughout the years, as the decade passes, do you become friends with Kay Baker, get to know her kids, so on?
Yes, we hung out quite a bit. She has kids, we have kids, so they constant interaction. So we spent a lot of time together.
As part of knowing Ms. Baker, did you come to know that at some point she started a relationship with a gentleman named Matthew Terry?
Yes, I did.
And at some point, did you ever get a chance to meet Matthew Terry?
Yes, I did.
Do you see him here in the courtroom?
Yes, I do.
And could you please point to him and describe what he's wearing so we know exactly who you're talking about?
He's in the second next to the other gentleman with glasses on, olive suit. White.
Your Honor, I'd ask the record reflect that he's identified the defendant.
The record shall so reflect.
All right. Tell me about how many times you think prior to May 28th you had hung out with or met with or talked with the defendant.
So my first interaction with him was roughly January of this year.
And how often do you think between January then and May you all would see each other?
So from January to May, more interaction was involved. So if I was to guess, it would be once a week, could be once every 2 weeks.
All right, so
Quite a
fair
bit.
to say 2 to 4 times a month,
Yes.
and that's like a 5-month period, so maybe 10 to 15 times.
Yeah, could be more, but roughly that time frame.
Most of the time when you got to see Mr. Terry, was it sort of like a couple's double date sort of situation?
It was always yes.
You'd go out with your wife, he'd go out with Miss Baker, and
Right.
the 2 couples would go out to dinner or whatever the case is.
Or it could be they came to our house with Kay's kids and our kids interacting.
Did there ever come a time where you had a chance to hang out with Mr. Terry, just you and him as guys?
Not just as guys. There was one evening where I took my boys and he took Kay's kids. We met at Chili's. We had dinner. Let the kids have fun. Came, shortly after that, we were all done, and that was our only interaction.
It's like a dinner.
Yes.
Okay. And so is it fair to say that through the multiple times you got to meet Mr. Terry, you had a chance to interact with him and get to know him?
Yes, sir.
During any of those social occasions, did you ever have a chance to be around Mr. Terry when he was drinking?
Yes, I did.
Did you ever have a chance to make observations? And I'm not going to ask you what the observations are, but did you have a chance to form your own observations as to what Mr. Terry's like when he's been drinking?
Yes, I did.
I want to talk with you about the night of Friday, May 27th, 2022. Did you end up going to the landing?
Yes, I did.
Did you have to work that day?
I did. That was, like you just said, that was a Friday. I got off work at 6. My commute time from work to home was about an hour. Ahead of time, I had ordered an Uber, and I got to the landing roughly 7:30, 7:45.
So when you get to the landing around 7:30, 7:45, is your wife already there?
She is.
Is Kay Baker there?
She is.
Is the defendant there?
Yes, sir.
And are there a couple other people that are there hanging out?
There were other people at a table, yes.
And your table, can you describe for the jury, where is this table at the business?
So we were outside of the restaurant bar. It was a fairly large table. There was a small little bar near where we were. There was roughly 6, 7 tables out in that area.
So it's like a patio outdoor seating area?
Outdoor setting.
And for most of the night, were you seated at the end or the head of the table?
Yes.
Who was seated to your right?
To my right, if I remember, I think my wife.
And who was seated to your left?
That would have been Matt.
And then next to Matt, was that Kay Baker?
I don't know, unfortunately, at that time.
Well, I mean, was she sitting with her boyfriend parts of the night?
She was there at the table, yes.
Okay. I mean, I'm sure people got up and
Got
went to
up,
the
and that's
bathroom
why I
when
don't
they were out.
remember if left side, right side.
Okay. Somewhere during the course of that evening, after you've been there for a couple hours, have people already started drinking?
People were drinking before I got there.
Well, but once you get there, because you
Once I
actually
get,
see it.
yes, people were drinking. Yes,
Okay. Were you drinking?
I was.
What were you drinking?
I was drinking beer.
Bud Light?
Yes, sir.
I had a feeling. What does your wife drink?
Typically, my wife drinks wine. Sometimes she drinks seltzer, and sometimes she drinks a mixed drink.
Okay. And do you know what a White Claw is?
It's a seltzer.
What's a seltzer for anybody who doesn't drink it? Is that like seltzer water, like it's just carbonated water?
It is an alcoholic drink. Unfortunately, I could not give you a true definition.
Fair enough. It's an alcoholic
It is an
drink.
alcoholic drink.
I just want to make sure people don't think it's like seltzer water. It's just
No.
carbonated water.
It is an alcoholic drink. It's low in carbs.
Okay. And so you're drinking beer, your wife's drinking White Claws. Do you remember if the defendant was drinking an alcoholic drink, a beer?
From what I remember, it was a mixed drink.
Okay, some kind of alcohol.
Yes.
Not like a beer. I mean, alcohol's a beer, but like a liquor.
It was a liquor drink, yes.
Got it. Okay. Did you see the defendant drink multiple drinks? Or do you think he only had one that night?
More than one.
Did you see Kay Baker drinking that night?
I did.
Do you remember what she was drinking?
I believe she was drinking similar to what Kelly was. Mixed drink, wine, seltzer. Again, I'm not 100% sure how much of each. Or
I'm sure you weren't keeping tab of each individual drink, but she was
I was
drinking.
not. Yes.
I want to talk with you about 10 o'clock at night, roughly, at the landing. You're already there, your wife's there, the defendant, Ms. Baker, are all there, correct?
Yes.
Do you remember there coming a moment where your wife got up, went to the bathroom, came back, sat down, and then there was some sort of like discussion between the defendant and your wife?
Correct.
Tell us about that.
So going back what you said, Matt had went to the bathroom shortly after Kelly, my wife, and Kay went to the bathroom. I don't know exactly the time frame of how long that was when Matt came back to the table where I was sitting. Him and I were talking a few minutes. My wife came back. Shortly as we were sitting, Matt had asked my Kelly who Kay was dancing with.
And did you at that moment have any idea what he was talking about?
I had no idea I was not inside.
And so I'm not going to ask you to repeat word for word everything everybody said, but I mean, can you tell me what the general tenor of the discussion was in that moment? Did your wife say, "Oh yeah, she was dancing with this guy"?
So her explanation was her and Kay were inside the bar. They were having a drink. There was talking, chatting going on. There was music playing inside the bar. Must have been a popular song that they liked. They just kind of did a little dance, raised their arms, hoo-rah-rah. There was a gentleman that passed him. She had said he was an elderly guy and that Kay did not dance with anybody at the bar, and to drop it, there was no big deal.
And did the defendant just immediately drop it and say, "Hey, I'm sorry," or did the conversation continue?
He did not say he was sorry, but the conversation was dropped.
Okay. And so the conversation ends, and then a few minutes later, does the conversation come up again for some reason?
I think he did ask more questions about it.
Okay. And asked who?
Kelly.
All right. And did they again have to address this sort of topic of dancing with another man?
Yes. And again, it was reiterated that don't worry about it, don't be jealous. It was another guy, that's not Kay, she's not who she is that she would be dancing with anybody. You know, you guys are boyfriend, girlfriend, just, you know, get over it, it's not a big deal.
At any point, did you ever notice Mr. Terry getting up from the table and then going over to Kay Baker, who was standing talking at another table with some other people?
Yes, I did.
And you don't know what they were talking about in that moment, I would assume.
I do not, I was not close enough.
But then did they, after that conversation took place, come back to the table and again start talking about the accusation of dancing with another man?
So when I noticed that they were talking, he came back first.
Okay. And then did Kay come over and start asking your wife about it, all that, about the
So
whole
she-
accusation again?
Yeah, shortly after she came back to the table.
And so are they again, your wife and Kay Baker, now having to explain to the defendant what did or did not happen as far as dancing?
Yes.
And is the defendant still insistent on, I saw it, I was there, or something to that effect?
It appeared it started to get a little bit more heated. I think he became more just aggravated, wasn't happy with what he saw with the situation. He didn't understand why Kay wouldn't confess, she wouldn't own up to her dancing with this specific individual.
And you use the word own up to. Do you remember him saying something to the effect of like just own up to it or just confess or something like that?
I did hear that.
So there's now a second conversation taking place about this allegation of dancing. Is that correct?
Correct.
At some point, did that conversation then again draw to a close?
He had talked to me a couple times about it, just bringing it up casually. You know, he was explaining to me why he didn't understand why this happened. I had told him, don't worry about it, forget about it. I highly doubt this happened. But it was brought up a few times with me.
All right, so now you're talking about a moment where you're having like a sort of one-on-one conversation, you and him.
Yes.
Are you seated right next to each other?
Yes.
So you're talking to him from just a couple feet away.
Correct.
And I want you to describe what you noticed about the tenor of his voice, the tone of his voice, his demeanor in general. Did he seem happy about this?
He was not happy. My thoughts were, as he kept bringing it up, he seemed aggravated. When you bring up something like that with another individual and another female and male, to me that would mean there's obviously some jealousy involved. He just wanted probably clarification of truly what happened at that time.
And so you had a conversation with him, and then I guess at some point the night went back to other conversations, other topics. The night just passed.
Yeah,
on.
we had maybe another one, and there was probably 2 or 3. They didn't last very long. I, again, told him, Matt, it's fine. I truly believe it's not a big deal.
So is it fair to say that throughout the course of the evening, you're now describing a conversation with your wife, then he gets up, he leaves, he comes back. Now there's another conversation with your wife and Kay, and separate and apart from that, you're describing at least one, if not a couple other times where it's just you and him still talking about this one topic, this accusation.
So I would say yes, just with him and I think maybe with another one, Kelly was at the table as well.
Okay. At some point, did the night start to draw to a close? People start packing it up, going home, making preparations to leave?
Yes.
And was that somewhere around 11:30? Were you still at the landing with your wife when Kay and Matt would have been packing up to go home?
So from my memory and on my wife's text messages, phone calls, I believe we did leave at 11:30. We did take an Uber home.
Okay, so at some point later you took an Uber home.
That is correct.
But do you ever remember there coming a moment after Kay and Matt have left that your wife gets a phone call where she appears to be talking to Kay Baker, and it's again about the accusation of dancing?
She did get that phone call.
You were not on that phone call, right?
I was not on the phone call.
It was not on speakerphone. You couldn't hear what was being said, could you?
It was not.
But at least from the end of the phone conversation you could hear, meaning your wife, did your wife get yet another phone call after The defendant and Kay Baker have left the landing, and she's having a conversation about the accusation of dancing with another man.
I'm sorry, did you say another phone call?
Right, just the one phone call. After
Oh.
they've left, is there still another conversation about accusations of dancing with another man?
There was that phone call, but then there was also a text message.
I got it, but you didn't send the text message, right?
I did not know.
So we'll rely on whatever your wife told us as far as that. I'm just asking, did you hear your wife on the phone having another conversation about the accusation of dancing with another man?
I heard her talking, but I don't know the specifics of that conversation. I'm only going by what she had told me after the conversation.
Fair enough. I want you to describe for the jury at the time that Kay Baker and Matthew Terry left, what can you tell me about observations you made about Ms. Baker in terms of how sober or not sober she might have been?
I don't necessarily know if she was sober or not. I know she appeared to be in a position where she could drive home. I know that night she did have drinks. That's all I could recall at this time.
Okay, so she wasn't like stumbling, falling down, anything like that.
No,
You thought she was perfectly okay to drive.
that's correct.
Can you describe what the defendant was like at the tail end of the night when he's saying goodbye to you and stuff, his level of sobriety?
He definitely had more drinks than Kay at that time.
Okay, and what are you relying on for your observations for deciding that he'd had more drinks and it was impacting him in any greater capacity?
I did not count how many drinks he had. I'm just going by our past and how much I had, that he had a similar amount. Mine was beer. Typically mixed drinks are a little bit outweigh more on the alcohol content of beer.
Objection, speculation.
Hold on. Just, I'll caution the witness not to speculate. Let's move on. Ask another question.
You thought he was having as many drinks as you did.
Correct.
But what I'm asking is, what did you observe in terms of any things he might have done that would have led you to believe whether or not he was sober or not sober? Did you make any observations about him?
My observation at that time would be slurring of words, eyes bloodshot, possibly, I remember a little bit of swaying, stumbling a little bit throughout the rest of the evening.
And so, again, I don't mean legally, because intoxicated has a legal definition.
Correct.
But did you think Mr. Terry was intoxicated that night?
I think he had his fair share of drinks.
I don't have any other questions. Thank you.
Cross-examination.
Good afternoon, Mr. Andrews.
Hi, how are you?
I'm good. How are you?
Good, thanks for asking.
You used a term I just wanted to clarify. You said things got a little heated. Do you remember describing it before as just a little tension?
Are you stating when Matt and Kay were talking away from me?
No, I'm talking about the conversation in general about this whole dancing issue.
I would say it got a little heated on the tone of his voice and the fact that it just kept being brought up.
Sure, but there was no fight, right?
There was no fight, there was no outburst, arguments throughout that night, no.
Great, and certainly no threats, right?
No,
Nothing physical happened,
no,
not even something as, not that any physical is ever good, but nothing even as minor as a push, anything of that nature.
no, I never saw that.
Okay. And in fact, you said Matt seemed fine and the topic was dropped, right?
Well, again, he brought it up, I don't want to say necessarily several times, but it was mentioned quite a few times, so he definitely seemed to be bothered, and based on bringing up those conversations, it appeared that it did anger him. It made him jealous of the situation, and he wasn't quite sure of what was going on.
Now, when you say angry, though, you've described it as something that really wasn't a big deal, right? Because we're not talking about something where he's screaming at anybody or making a scene, right?
Correct?
So this was something that pretty much was discussed, and that was it. There was no scene, nothing that happened, no issue that was caused as a result.
There was no scene, but again, my reason or definition of anger was just as time went on, it just seemed to be his tone seemed to be louder, his demeanor, facial expressions.
You certainly didn't think anything physical would occur, right?
Absolutely not.
You wouldn't have let Kay leave with someone you thought would harm her, right?
That is correct.
Could I just have a moment? Nothing further.
Redirect.
I don't have anything, Your Honor.
Is be released or subject to refund? Mr. Diaz, can you check for me, is that microphone on the?
The green light is turned on.
Okay.
Yeah, the green light here is definitely turned on. Now it's off. Now it's on.
Make sure you leave it on. Oh, I'm sorry. Ms. Johnson, good afternoon and welcome, ma'am. If you'll come forward and be sworn, you'll raise your right hand, please. Do you swear or affirm any testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, ma'am. If you'll follow the bailiff to the ramp that leads up to the witness chair, please watch your step. When you get to that chair, go ahead, have a seat, make yourself comfortable. That microphone is adjustable.
Afternoon, ma'am. If you would, please introduce yourself to the jury.
Hello, I'm Tara Johnson.
Ms. Johnson, do you know someone named Kay Baker?
Yes,
Was Ms. Baker a coworker of yours?
yes,
And how long have you known her then in total?
2 years.
I want to talk with you about Friday, May 27th, 2022. Did you and Ms. Baker, after work that day, go to a work function, a work party at a place called the Roadhouse?
We did.
And were you there for a couple hours hanging out with other coworkers?
Yes,
During that time, was Ms. Baker drinking?
yes,
And at the end of the period of time, somewhere around 5:30, did you all decide to split and go separate ways?
no, we decided to get back together. It was just the afternoon, and it wasn't all that long. So we both live in the same direction. We decided we would meet up somewhere in the middle, and I would bring my spouse, and she was going to go get her boyfriend and some other friends from that worked with us previous years,
And
and meet up at a place kind of in between the both of us.
what place did you pick to meet at?
The landing.
And so somewhere later that evening, after you had parted, you to go get your husband, her to go get her boyfriend, did you all meet back up at the landing?
Yes, we did.
And when you arrived, who was there?
I think I was the last one, so it was, I came with my husband and my son, and another colleague from school was there with her boyfriend, Miss Juarez, and then Kay was there with Mr. Terry, and then also there was Kelly Andrews there with her husband.
And so you said Mr. Terry or Matthew Terry. Do you see Kay's boyfriend in the courtroom?
Yes, I do.
Could you please point to him and describe what he's wearing so we know exactly who it is you're talking about?
He's wearing, I think it's a gray suit. He's in between two people sitting in the middle.
All right, and he's the one in the middle there?
Yes,
Your Honor, I'd ask the record reflect you identify the defendant.
Record shall so reflect.
All right, so this gentleman is there with Kay Baker.
Mhm.
Is that yes?
yes,
You gotta answer out loud. And do you understand this to be Ms. Baker's boyfriend then?
yes.
So tell me what the atmosphere is like when you first arrive at the landing and all the people are kind of already assembled.
We were in a good mood. We were celebrating, and they had drinks out, and we came in. We ordered. I think my husband ordered some nachos, and then we ordered some drinks. Everybody was talking. We introduced ourselves. Some of the people I didn't know until that night.
And so as the night's proceeding, are you guys having drinks and eating appetizers or food or whatever it is?
Mm-hmm. And then we were just talking, and we're talking about meeting up again for Memorial Day. Miss Juarez lived near
Let
the
me stop you
beach.
there. I don't want to get too much into what everybody said because I want to run into hearsay problems, okay? So what I want to do is I want to instead focus your attention very specifically to somewhere around the 10 o'clock hour. Did you realize there was some sort of disagreement, discussion, argument occurring between Ms. Baker and the defendant?
Yes.
All right. Tell us what you remember happening that kind of first drew your attention.
Well, Kay and went to the bathroom, and Kelly went to the bathroom. At least I assume that, because they both got up, went inside, and we were still sitting at the table with my husband and my son. And then they came back, and they stopped to talk to someone else on the side that worked there, I believe. And all of a sudden, you could just see that things had changed. It became a little tense. And my husband already wanted to go. When he's one of those guys that when he's ready to go, we got to go. He had my purse sitting ready to go. And I told him, I said, just give me a minute. Things seem tense. And I overheard them talking about Kay. Well, as Kay was inside, he, Mr. Terry, accused her of dancing with another man and was upset about it. And Kay said that she wasn't. And I just didn't want to go on that bad a note. I started to feel the tension, and I asked my husband, just give me a minute. And I kind of leaned in toward them, and he was talking, and she was talking. He was right next to me at that point, because there was no one sitting, because it was Mr. Terry, then Kay, and then myself. But she was across the table at this point, because they had just come from out in the building.
All right,
and we were outside.
You're wandering way far afield here. Let me get you back on track, okay? I'm going to put on some video.
Okay.
And I'm going to play a few seconds. I'm starting at 10:11:28 a.m.
Mm-hmm.
This is State's Exhibit number 53, Disc C.
Okay. Yeah, my son's leaving.
All right, and I'm just going to pause it here for a second at 10:11:45 just to get all of the main people here identified. I'm going to start on the left. There is a gentleman with a white hat. Who is this?
That's my husband.
And he's got his arm around somebody else. Who is this?
My son.
Okay. Here, seated at the table with their back to the camera, is a person in black. Who is this?
Myself.
Next to you, there's a gentleman just starting to take a seat in a green shirt. Who's this?
This is the defendant.
There is a gentleman next to him in a blue shirt at the head of the table. Who's this?
Mr. Andrews, I believe.
Opposite the table from you is a
Okay.
female in red,
Okay.
and then next to her is another female.
Kelly.
All right, so now we've got everybody identified. I'm going to play some more again. All right, so we just watched a few seconds there. Ms. Baker appeared to be pointing at herself, and now Ms. Andrews appears to be putting her hand up, like exposing her palm in the direction of the side of the table where Mr. Terry is seated. Is this the moment that this accusation and subsequent conversation is taking place?
Yes, and the reason I remember is because my son wanted to say goodbye to Kay, but already saw that something tense was going on, so he just left.
And 10:12:19, is that your son then kind of motioning and then walking away?
Mm-hmm.
This is the time your son is leaving?
Mm-hmm.
You got to answer out loud.
Yes, sir.
Okay. So you know that this is the time the argument is happening.
Yeah.
Now, there appears to be a conversation going on at the table involving Ms. Andrews, Ms. Baker, and Mr. Terry. Is Mr. Terry making the accusation that Kate Baker was dancing with another man?
Yes.
Does Ms. Baker, in return, deny it?
Yes.
Does Ms. Andrews also deny that that ever happened?
Yes.
Okay, and I want you to walk us through the portion where you get involved in the conversation now. Tell me what, if anything, you say and what happens.
Well, I just wanted, I didn't want to leave on a bad note, and so I thought I could appease the situation. I also had not drank as much, I think, as the others. Can't say that with 100% guarantee, but I felt like I was going to try to smooth it over. So I I looked at both of them, and I looked at him, and I said, you know what? Don't worry about it. You obviously are, this is silly to even be upset about, because think about it, you both love each other. I said, must be because you're jealous and you think that she was dancing with another guy and this has gotten you upset, but you don't have to worry about it. You're jealous enough you love her enough to be jealous, but she loves you enough to have not even noticed that guy.
All right,
so it's all good.
Let me stop you there. You keep saying you. You say you're jealous.
I was talking to Mr. Terry.
And when you make a statement to the effect of telling the defendant he's jealous, what, if anything, does he do?
As soon as I said those words, he whipped his head around and he said, "Wait a minute, I'm not jealous. I have no reason to be jealous." And I said, "No, wait, you are, because you're upset about this. You think that she was dancing with this other man and it's upset you." And then he said, "No." He goes, "Because jealous implies envious, and I'm not envious." And I said, "Well, I don't mean it that way. I mean that you're jealous because you're like a boyfriend who cared about his girlfriend and you were protective of her." And he goes, "Well, of course I did. I look at her. She's beautiful and I love her." And I think he was okay with that. At first I thought I made a mistake and made it worse. And then it kind of settled down and it seemed like it was okay. And things weren't as tense. And
All right, I'm going to play some more video. 10:12:30, Mr. Terry does not appear to be talking to her, interacting with you directly. Is that correct?
Yep.
It looks like he turned to you for a second.
Mm-hmm.
Is that a yes?
Yes.
All right, right there at about 10:12:56, it looks like you leaned over to him. Were you saying something to him?
Yep.
And then he looked at you again.
Yep. But this time it was like eyeball to eyeball, and he just whipped his head around. That was when I mentioned the word jealous. And I thought I made a mistake.
Ten 13:22. Is that you and Mr. Terry talking to each other?
Yes.
All right,
Although
so-
I'm having trouble seeing it, yes.
Well, if you need to stand up or reposition,
Do you
please
mind?
do. I know it's a weird angle.
Yeah. Yes.
All right. So is there a moment there where you're talking with Mr. Terry?
Mm-hmm.
Is that yes?
Yes.
Okay. And so you are talking inches apart. Is that fair to say?
Yes.
I want you to describe the mood at the table while all of this is transpiring.
It was tense. That's why I didn't want to leave right away. It was tense.
And I want you to describe to the jury Mr. Terry's tone or tenor of his voice, his demeanor, any observations you made about how he was behaving.
He seemed upset. And he was kind of not listening to what I was saying until what struck me the worst was when I used the word jealous and he whipped his head around. That was the first time he actually acknowledged what I was saying or me.
All right. And you used the word upset.
Mm-hmm.
If I have a favorite football team, my favorite football team on the
he
weekend.
was mad.
He was mad. Okay.
Yes.
Is that your husband putting the chair away?
Yes, this is my husband saying, "Let's go." For probably the 5th time.
Ma'am, is it fair to say that this conversation about the accusation and whatever went on for at least a couple minutes? Is that a yes?
Yes.
This was not like he said one thing, somebody said, no, that's not true, and it was over?
No.
You had not met Mr. Terry before that night, correct?
Correct.
That's the only time you ever met him?
Yes.
Okay. Did you notice if Mr. Terry was drinking that evening?
Yes.
Did you make any observations about Mr. Terry's sobriety?
No, it wasn't until that point that I thought he didn't seem all that drunk. I thought he might have been drunk when he started to get upset like that.
Okay. Did you end up leaving not too long after this?
Yes.
I mean, by 10:30, 10:45, are you and your husband gone?
I know the exact time because when we got in the car, I texted Kay to say thanks for the invite. I had a great time, and that was at 10:44.
All right. So by 10:45, you're in the car and you're home.
Mm-hmm.
Is that a yes?
I don't know if I was home, but I was definitely in the car on my way home.
Fair enough. You're correct. You were at least in the car on the way home.
Mm-hmm.
Is that a yes?
Yes.
You have no idea what transpired after 10:45 at the landing.
No, sir.
You have no idea how much drinking did or did not occur after 10:45 at the landing.
No, sir.
Pass the witness, Your Honor.
Cross-examination.
Yes, sorry.
Good afternoon, Ms. Johnson. You just said that you had only met Matt that night, right?
Mm-hmm.
Sorry,
Yes,
court reporter,
yes,
you've
ma'am.
got to answer out loud.
Sorry.
And because you only met him that night, you have no history of judging his demeanor, his intoxication, anything of that kind, right?
Correct.
Okay. And you described him as getting mad. Perhaps his mad or anger or upset or whatever you viewed came from a stranger interjecting in a discussion he was having with his
Objection calls for
long-term girlfriend.
speculation.
She,
Sustained as to speculation.
do you know what he was mad about?
He was upset because she was dancing with another gentleman, in his opinion.
Well, in regard to what he might be upset about, you really don't know if that's what upset him or if it was you interjecting in something that had nothing to do with you, right?
Actually, he stated that he was upset about that prior to me saying anything.
Didn't you say that you thought it was you using the term jealous that actually made things worse?
That could be.
Okay, so
I
it
don't
may
know.
have had more to
That I
do,
can't answer for either, but he was already upset before I used the word jealous.
and it may have had more to do with you calling him a stranger jealous about an incident you didn't even view, right?
No, what I was saying was that before I ever interjected, he was already upset.
Okay. You didn't view the dancing, right?
No.
You had never met him before, right? You weren't a long-term close friend like Kelly and Sean were, right? And you just jumped into this discussion, right?
Yes.
Okay. You were drinking too that night, right?
Yes.
In fact, what you were drinking was a vodka drink called a Moscow Mule.
Yes.
Your husband and son were both drinking as well.
Yeah.
Okay. Now, you said that you left because you thought everything seemed fine, right?
Yes.
Court reporter said that things had cooled down, right?
Yes.
In fact, things had cooled down so much that you sent Kay a text saying what a good time you had, right?
Yes.
And talking about getting together on another date, right?
Correct.
So nothing happened that prevented you from wanting to get together on another date, right?
No.
And when you first heard about Kay's death, what you thought had occurred was a drunk driving accident, right?
That's what I assumed.
Could I have a moment, Your Honor?
Yes.
Nothing further.
You're right.
Ma'am, just to clarify, when you initially came to the erroneous belief that there was a drunk driving accident, did you know how Kay Baker had died?
No. Oh, well, we were given a text message from the school and.
All right,
just
but I don't want to talk about what
No.
people said. I mean, had people specifically like shown you pictures of what had happened?
No, nothing at all.
Had people talked with you to tell you I was there, I saw it?
No. And I didn't know how long she stayed or how much she drank afterward either.
Okay. You just used whatever little information you had and arrived at a
Correct.
conclusion. Thank you, ma'am.
Excused or subject to recall?
She's excused.
Excused by the defense?
Excuse.
Thank you, ma'am. You may step down. You may be excused as a witness at this time.
And can we approach him before we bring him in?
Yes.
Bryant.
Gibson?
Brian Gibson, yes, thank you.
I don't see him on the list.
I think he may be on the next.
What number?
He's number 9, Your Honor.
Oh, I'm sorry. Yes, I see it. Detective Gibson, good afternoon and welcome.
Good afternoon, sir. How are you doing?
Good. Will you come forward to be sworn as a witness?
Yes, sir.
If you'll raise your right hand, please. Thank you. Do you swear or affirm a testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, Detective. If you follow the bailiff to the ramp
Good afternoon, guys.
up to the witness chair, please watch your step. Go ahead, have a seat, make yourself comfortable. That microphone in front of you is fully adjusted. You may proceed.
Thank you, Your Honor. Good afternoon, Detective. Please introduce yourself to the jury.
How's it going? I'm Detective Brian Gibson with the Hillsborough County Sheriff's Office.
All right, Detective Gibson, how long have you been with the Sheriff's Office?
Coming up in March, will be going on my 10th year.
And what is your current assignment with the Sheriff's Office?
I am a detective in our Criminal Investigations Division assigned to the Homicide Section.
And how long have you had that assignment?
I've been in the Criminal Investigations Division for over 4 years now and with the Homicide Section for about 2 years now.
All right, I'm going to draw your attention back to the month of May of this year, specifically the evening of May 27th into the early morning hours of Saturday, May 28th, 2022. Were you involved in an investigation regarding the death of Kay Baker, which occurred on Kite Ridge Road, Kite Ridge Drive in Hillsborough County, Florida?
Yes, sir.
Give me an idea when you first arrived and what did you do when you arrived? When did you arrive?
So I got there, like you said, in the early mornings around 2:14 in the morning. I then got with my supervisor who was on scene, and I learned that I was going to be assigned as the assist detective to the lead detective, Detective Ratu, and we were going to be investigating the case.
So you were going to assist Detective Ratu. You basically work together as a partner with him and do what has to be done.
Yes, sir.
All right. Do you recall the first assignment that you had, the first thing that you did?
The first thing that we did was we made our initial observations of the incident location.
Did you, when you said the incident location, what location are you talking about?
The location in between 6209 and 6211, or 11 Kite Ridge Drive.
The place where Kay Baker was found.
Yes, sir.
Did you at any point go inside Kay Baker's residence 6207?
Later on, yes.
Later on. So the first place you went is to the location of Kay Baker's, where she was found. What assignment, if any, did you have relating to that particular part of the investigation?
I had no assignment at that part. I was just with Detective Ratu, and he started to conduct some interviews with some neighbors, so I just assisted him with those interviews.
At some point, then, did you leave those interviews and do anything else related to this investigation?
Yeah, after we left the interviews, then we responded to the north side of the neighborhood. In between the neighborhood and Lithia Pinecrest Road, there was a large brush area where we responded to Lithia Pinecrest Road over there.
Okay, and prior to that time, did you go inside the residence, or was that later on?
That was later on.
Later on. Okay, so what was the purpose of you and Detective Ratu going into that area that you just described?
We made some observations in between the houses, and then in the backyard leading to that bushy area, it looked like it was trampled down. So we were just looking for any possible evidence on that side of the roadway.
What did you notice, if anything, of interest to you and Detective Ratu in the backyard of 6207 or 6209, Kite Ridge?
What appeared to be blood drops on the ground.
And so is that part of the reason that piqued your interest to go into the adjacent area, the wooded area that you talked about?
Yes, sir.
You noticed there was some of the areas were trampled down. Did you continue looking around at that point?
Yes, on the other side, on the north side of that bushy area, then we started to look around on the ground, and then I found what appeared to be blood drops on the ground on that side of the road.
Is it dark or light at that point?
It's dark.
So you and Detective Ratu are using flashlights to make your observations?
Yes, sir, that is correct.
Okay, and based upon your suspicion that there were blood drops back in that area as well, what did you decide to do along with Detective Ratu?
We contacted the HCSO Canine Unit, and a bloodhound responded to that area. At that point, Detective Ratu and I did not want to contaminate the area any further, so we actually left the area. There was a marked deputy that was parked there, and like I said, we exited the area to continue on with interviews at that point.
All right, I'm going to show you a few photographs from exhibit, what has been admitted, exhibit number 20A through E. I'm going to show you those photographs. There's A, B, C, D. Do you recognize those photographs?
Yes, sir.
Yeah, and what are they?
They're going to be pictures of the blood drops that were found on the north side of the bushy area, just south of the Pinecrest Road.
Okay. And that's what caused the canine units to be contacted. You got out of the area.
Yes, sir.
At some point, did you become aware that an individual had been apprehended back in that wooded area?
Yes, sir.
And did you and Detective Ratu or other officers have any interest or concern about discovering a weapon?
Yes.
A weapon that caused the death of Kay Baker?
Correct.
And what efforts did you make along those lines to try to discover a weapon?
In the area where he was found, we used metal detectors that morning when the light became available. We used hand metal detectors. We conducted grid searches that morning to look for any possible weapon or object that could have been used.
That was in daylight.
Yes.
That was the following day. So that would have been Saturday, or was it any days subsequent to that? Do you recall?
It would have been when the sun rose that morning once we got out there.
Describe the area that you were searching, the wooded area, the foliage, anything like that, but as it relates to being able to conduct a thorough search of that area.
It was a very thick, wooded area. We spent a good amount of time looking in that area. It was very thick, a lot of foliage and stuff like that.
So metal detectors were attempted to be used?
Yes, hand metal detectors and then little wands that we were using on the ground level as well.
Okay. Well, was any weapon ever found?
No, sir.
While you were, before it got light and while you were still there at the scene, did you also attempt to locate any weapon of interest to you?
Yeah, we looked along the areas that we were looking and searching for on Little Pinecrest Road.
You found nothing?
No, sir.
All right. Other than what you've described, did you have any other part in this investigation other than assisting Detective Ratu?
No, sir.
Did you have any part in the marking of any suspected evidence, collecting any evidence? Did you have any responsibility along those lines?
No, sir, I did not.
All right. Thank you, Detective. I have no further questions. Pass the
Cross-examination.
No, thank you.
Can this witness be released by the state or subject to recall?
He can be released, Your Honor.
And by the defense?
He can be released.
Jackie, thank you. You may step down. You may be released as a witness at this time.
Thank you very much, sir.
You're welcome. I'll ask the state to please call your next witness.
Yes, sir.
Yes, Your Honor, the state will call Detective Davis.
I'm sorry?
Detective Kelsey Davis.
Davis?
She's number 22.
Thank you. Detective Davis, good afternoon and welcome.
Good afternoon, Your Honor.
You'll come forward to be sworn as a witness wherever you're comfortable. If you'll face me, and please raise your right hand. Thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, Detective. If you'll follow the bailiff now to the ramp that leads up to the witness chair, please watch your step. When you get to that chair at the end of the ramp, go ahead, have a seat, make yourself comfortable. That microphone in front of you is fully adjustable. You may proceed, Mr. Dirks.
Thank you, Your Honor. Thank you, Your Honor. Good afternoon, Detective. Would you please introduce yourself to the jury?
Good afternoon. My name is Detective Davis. I'm with the Hillsborough County Sheriff's Office.
And how long have you been with the Sheriff's Office?
Approximately 6 years.
And what is your current assignment?
I'm in the homicide section.
And how long have you been in the homicide section?
Since February of 2021. 22, I'm sorry.
All right, and so were you a homicide detective back in May of this year, 2022?
Yes, I was.
On the morning of May 28th, 2022, did you have any part in the investigation surrounding the death of Kay Baker occurring on Kite Ridge Drive in Hillsborough County, Florida?
Yes, I did.
Tell me what first caused you to become aware that you were going to be involved in this case?
So I received a call from my sergeant, Justin Fisher, from the homicide section around 5 o'clock in the morning, advising me of a homicide investigation that was ongoing and requested that I respond to the incident scene.
And approximately what time did you arrive at the incident scene?
About 6:11 in the morning.
Okay, you arrived at 6:11. Did you speak with anyone? Did you collect any information? What was it when you initially arrived there?
Yes, sir. Upon arrival, I spoke with Detective Van Gilder. He had been working since the early hours of the morning already on the case. I was instructed to take over from his duties, cataloging the crime scene, documenting any remaining pieces of evidence that needed to be diagrammed, photographed, and so on.
So you're basically taking over for a very tired Detective Van Gilder.
That's correct, yes.
All right. In your discussions with the other officers who had already been there, did you become aware that 6207 Kite Ridge was a residence of interest?
Yes, I was advised that that was the residence of the decedent.
All right. So you're taking over for Detective Van Gelder. What was the first thing that you did pursuant to those responsibilities?
I learned that there had been a search warrant that was authored and served at the residence, 6207 Kite Ridge. I then finished whatever there was left to be done within the house, which was very little. I took a look inside, saw that there was an open window that appeared to lead outside into the residence. I learned after speaking with Detective Van Gilder that there appeared to be quite a bit of blood outside of the incident scene, and my primary task was cataloging that blood that was located kind of outside of the residence and around the immediate area.
Were there other crime scene investigators that you worked with while you were there?
I did. I worked with CSI Durr and CSI Douglas, who both assisted me in documenting the incident scene.
Okay. You first you finished up whatever had to be done in the inside.
Yes.
After you finished that, then you worked to the outside.
Yes, sir.
Did you have any part or participation in the determination of any evidence markers which were going to be located in that backyard area?
Yes.
Did you work with other crime scene investigators along those lines in those markers' placement?
Yes, I did.
And do you recall what sort of evidence that you noticed out there which were marked?
Yes. So beginning at 6207, as well as from where the decedent was located, We noted quite a bit of blood that appeared to kind of be directed within a trail pattern. We walked that line, walked the entire area, and marked any place where we found any drops of blood or anything that resembled that.
And were those evidence markers had either numbers or letters associated with them so they could be specifically identified?
Yes, they were both numbered numerically as well as with letters of the alphabet as well.
Were any swabs taken from any of those markers?
Yes.
Did you play any part in the collection of the swabs?
No.
Did you, after the swabs were taken, did you have any part in the chain of custody of those swabs?
No.
Those who had responsibility over either the swabbing or the taking into custody of those swabs?
CSI DER.
And was Brandon Douglas also involved?
He was, yes.
And did he also take part in either the collection of the swabs or the taking those items into evidence?
Yes, any items of evidentiary value at the time on scene were collected, and chain of custody were deferred to crime scene investigator Douglas and crime scene investigator DER.
And you mentioned that there was some suspected blood in the backyard.
Yes.
Do you remember that there was also some blood or suspected blood continuing at any other place other than the backyard area?
Yes.
Tell us about that.
So directly behind the residences in the neighborhood, the backyard's all backed up to a rather kind of brushy, overgrown area. It was a fairly thick, kind of clumps of grass, low-lying scrub, palmetto bushes, those kind of things. And through there we located several drops of blood on some of the low-lying brush. And then outside as well, beyond that kind of brushy area, was kind of a thin kind of median of grass that separated right onto Lithia Pinecrest in the roadway. So traveling a little bit further south, down from where the house was, we also located several additional drops of blood. All the way down approximately 8 house lengths in front of another house, 6223 Kite Ridge, which is right in the backyard. There was kind of a break in that kind of brush wooded area where we located quite a bit of blood, and that was the area where Mr. Terry was eventually taken into custody.
All right. And did you work with those same 2 crime scene investigators in marking those areas of interest?
Yes, sir.
You mentioned that you were in the backyard area of 6207 and 6209. I'm going to show you a few photographs if you would take a look at those. I've got first 9A. And 9B. And 9C. Do you recognize those photographs?
I do.
Put it back. You were zoomed in.
I'm going to try this again. 9C. 9A. And 9B. Now that you've got a better look at it, do you recognize those as well?
Yes, I do.
Yeah. What do those photographs depict?
Well, those were the area of the immediate crime scene and behind the backyard of 6207, 6209, and 6211 Kite Ridge Drive.
Okay. There's no evidence markers back there at that point.
No.
Okay. So those photographs taken before any markers were placed there?
Yes, sir.
Were eventually markers placed there after you worked with detective crime scene investigators DER and Douglas?
Yes, sir.
All right. When you arrived at the scene, were you aware of there was a vehicle parked in the driveway of 6207?
Yes.
Can you show you what has been marked for identification or admitted as 10A? Do you recognize 10A?
Yes, I do.
Okay. And what is 10A?
That is a vehicle that is registered to Matthew Terry.
All right, when you were in 6207, did you notice any damage to any of the doors
Yes, I
inside
did.
that residence?
Yes, sir.
Did you ask the crime scene investigators to make sure they had photographed those areas and documented their locations?
I believe Detective Van Gilder had instructed them to do so prior to my arrival.
All right. Did your investigation also include the attempt to locate any weapon that might have been used in this incident?
Yes, sir.
Tell us about that, if you would, please.
So after documenting the initial crime scene, making any notations, preserving any evidence that we needed to preserve, right in the area behind 6223 Kite Ridge, which I mentioned was 8 houses down, just at the south of the incident scene, where our defendant was taken into custody, we did a line search of that immediate area, looking for anything that could be utilized as a weapon, anything sharp, anything of that nature that might fit that description. Part of that process was using several types of metal detectors to kind of scope the area. We did a line search of that immediate area, which is detectives or CSI or law enforcement individuals lining up sequentially and kind of just going down on a line, not neglecting any kind of area in our immediate reach or attention.
All right. So you mentioned that there were 2 different locations along that wooded area. You mentioned the address 6223, I believe, and then that also includes 6207 or 6209, which was part of your investigation.
Yes.
Was that wooded area extending all the way from 6207 all the way to 6223?
Yes, the wooded area and the grassy median were continuous all the way from 6207 all the way down to where we located Mr. Terry.
Okay, you said you conducted a line search. Were you and your fellow deputies able to stand side by side and do a line search all the way through the entire wooded area between 6207 and 6223?
As far as we could, yes.
All right, and did you discover anything of interest or of evidentiary value when you searched that area?
No, sir.
Were you able to, when you searched, were you able to get all the way in the heaviest part? Were you able to actually get down where you could see to the ground?
Some parts were obscured from view. Again, it was trying to get in as best we could.
So Detective Duran Douglas marked everything that you instructed them to mark?
Yes, sir.
Did you take any part in the collection of any evidence in this case?
No, sir.
Did you conduct any interviews with any neighbors?
No, sir.
Was it your understanding that much of the investigation had been initiated before you ever arrived?
Yes, sir.
I think that's all the questions I had, Detective. Thank you very much.
Thank you.
Cross-examination.
Good afternoon, Detective Davis.
Good afternoon, ma'am.
Now, you said that by the time you arrived, it was 6:11 in the morning,
Yes, ma'am.
and you're there basically to take over for Detective Van Gilder,
That's correct.
because there needs to be at least one detective there that's supervising the crime scene,
Yes, ma'am.
and so that would have been your role, is just taking over at that point.
Yes, ma'am.
So as far as the investigation goes, earlier you testified that's where we found the suspect or the defendant. You're referring to Mr. Terry,
Yes,
correct?
ma'am.
Okay, but you weren't there when Mr. Terry was placed in handcuffs and transported.
No, ma'am. I did not see Mr. Terry at any point during the investigation. He had left the scene prior to my arrival.
Okay, so all that's done prior to you even arriving.
Yes, ma'am.
And this wasn't a case where you were investigating like another portion of the case and then just arrived to the crime scene. The crime scene was the first place where you started.
That's correct.
Okay. And so the investigation that's going on at 6207 Kite Ridge as far as documenting the interior of the residence and the exterior, the majority of that also had been done prior to your arrival.
Yes, ma'am. That's correct.
So you're just making sure that nothing is missed, I guess.
Yes.
You're not locating items of evidence yourself. It seems like all of that had already been done.
Yes.
Locating any potential blood evidence, marking those, taking photographs that Mr. Dirk showed you, all of that was done prior to your arrival.
Yes, ma'am.
Okay. So the part that you're really participating in is doing the research, I guess, on the vehicle that was in the driveway. Is that something you did?
No, ma'am.
That was also done prior to your arrival?
Correct.
Okay, so that's just something that you're told.
Yes, ma'am.
And you don't end up searching that vehicle that Mr. Dirk showed you, the silver car that was in the driveway?
I do.
You do? You search that?
Yes, ma'am.
Okay, so that's something that you participated in.
Yes, ma'am.
And you don't end up collecting any evidence from that vehicle?
No, ma'am.
And then you participated, you said, in searching that area behind the residence as soon as daylight came with other detectives and crime scene?
Yes, ma'am.
And you all don't locate anything?
No, ma'am.
You're not involved in any other part of the investigation?
No, ma'am.
If I could have one moment?
Yes.
Nothing further.
Redirect.
No, Your Honor, thank you.
May this witness be released
Yes, Your Honor.
and by the defense.
Yes, Your Honor.
Thank you, Detective. You may be released as a witness at this time.
Thank you, Your Honor.
You're welcome. State, did you have another one?
No, that is it.
That's it? For today? All right, not a problem. Ladies and gentlemen, as promised, I was going to get you out of here before 5 o'clock. Again, I don't know if any of you have not yet voted, but you should have plenty of time to get to the polls if you need to. We are going to start tomorrow morning at 9 a.m. Hopefully tomorrow I'll have some more information on the tropical storm and information on whether we're going to be open on Thursday. But as of right now, it does look like we are, unless something changes. But I'll have more information again tomorrow. Please do not discuss this case amongst yourselves or with anyone else. Please do not do any research related to this case and avoid all reports of this case outside of the courtroom. We will see you back at 9 a.m. Have a safe trip home. All rise for the jury. Jury has exited. Everyone may be seated. Hold on, I got another email regarding the schools. They're monitoring the situation prior to making any decision. All right, there's a lot of information there about school buses that can't operate at certain wind levels, so they're going to keep monitoring and let us know.
Judge, if we could first, I just want to give you a heads up as to where I think we are in terms of witnesses, because I'd like to clarify something with you. Anna Cox absolutely positively has to be my last witness because she has to basically rely on all the evidence already being admitted, including the DNA.
Who is Anna Cox?
She is my blood pattern expert.
Okay.
And so she needs to rely on, for example, the DNA evidence and all the photos and so on and so forth. So she absolutely has to be my dead last witness.
I don't have a problem with that.
And Alyssa Troutman is scheduled to be my second to last witness. So for tomorrow, what we have left, other than Ms. Troutman and Ms. Cox, are Dr. Perkins, the autopsy doctor, Dr. Devers from the medical examiner's office, who did not participate in the autopsy, but I have a suspicion may be a bit of a contested witness.
Can you tell me what you
Dr. Devers is going to opine that the defendant's wounds on his neck could be, she will not say definitively that they are self-inflicted, but she will talk about, if you remember from opening statement, she will talk about what are called hesitation marks, and hesitation marks are a sign of potential self-inflicted wounds. And I fully expect that Ms. Perry and I, or Ms. Perry and Mr. Dirks, will be going back and forth about her quite a bit. That's just my guess. There's also Brandon Douglas, who's going to introduce, I think, about 20 pieces of evidence tomorrow, photos and physical evidence. Robert Durr, who's only going to introduce two. Brandon Douglas, they're towards the bottom. We skipped them
here,
today.
15. See him.
Yes. Robert Durr, who's going to do 2 large packets of photos, what I would generally refer to as the blood trails. Dr. Mendoza, who we still need to litigate a motion about, potentially. And my lead detective, Detective Ratu. And I can also call Detective Watson at any point. He literally works across the street, so he can be here within 5 minutes.
What's the deal with Mendoza, Dr. Mendoza?
Dr. Mendoza, so this is the issue, and if Ms. Perry disagrees, certainly she can correct me. The defense filed a motion regarding the medical records and statements in the medical records.
That was the unreliability motion.
No.
Oh.
There was a separate. There was the unreliability motion to throw out the medical records in total. That was denied. Then we heard it again on Monday. It was denied a second time. There is a separate argument where Ms. Perry wanted to limine out any reference in the medical records where the defendant is notated as not answering questions of doctors. By anyone, really, but nurses, doctors, staff of the hospital. Okay? We litigated that motion. Judge Williams initially reserved ruling. Then, I believe it was at pretrial, came out and told us that he was granting the motion. This is the thing where I mentioned that I had the...
Granting their request to
limine out
any
section where it's noted the defendant was not answering questions. That he's not replying. Okay? At that hearing, and again, I have the audio, I can send it to you, but you kind of deferred it back to Judge Williams.
Well, that may have changed now. Judge Williams is most likely going to be out for the rest of the week.
Okay, so then I will send you the audio so you can hear it in advance, but I don't think that I am mischaracterizing it. At that moment, I said, Judge, does your ruling also apply to a witness who testifies live, who can say that my understanding of Judge Williams' ruling was the records are unclear where law enforcement is at the moment the defendant is not answering any questions and whether or not they're in any way participating or influencing the defendant's decision to not answer questions. And so I said, if I have a live witness who can say where the police are standing, even though you've already kind of heard it, that was the question of Deputy Curtis about where were you when the defendant was in the emergency room, the 15 feet, which I don't think this is 15 feet, I think it's a lot more, but whatever, he said 15 feet. I asked Judge Williams, does that apply if a witness testifies live and can clarify that law enforcement is not participating in the questioning? Dr. Mendoza was deposed, and she said the defendant would not answer her. She was clearly asking him questions for medical diagnosis, trying to discern what caused his injury so she could figure out how to treat him. And she says, he looked me in the eye, and then he looked away, and he never answered me. So I asked Judge Williams at pretrial if his ruling encompassed live testimony where we don't have the uncertainty of where the police are from the medical records.
So essentially that you want Mendoza to say exactly what you just said. She asked him a question, he looked at her, and he looked away.
He refused to answer her.
And Judge, the whole point of the motion and what has already been ruled on is that that is a comment on the defendant's right to remain silent. The officers were present. You heard from Deputy Curtis, who said he was there during not only the time prior to the defendant being transported, he actually followed the ambulance, And then the defendant was in custody the entire time. Additionally, in the records themselves, on page 31, it says, officer at bedside indicates that he's not able to leave the room and must remain. Additionally, page 58, 2 officers bedside. They're asking questions in front of police officers. Of course he can't answer. And him not answering and them commenting thereon is a comment on his right to remain silent.
What does the case law say, though, on whether a doctor's question for medical purposes constitutes interrogation?
There isn't going to be anything specific unless you can find one that specifically talks about when officers are at the bedside holding the defendant in custody while the officer's doing that. By the way, in the records, one of the doctors actually specifically notes that they asked the officers to step out so that he could answer questions for a medical purpose, and the officers refused.
And that is all true, and those portions are gone. The point that matters is the defendant's first admission to the hospital. Literally the first minutes he's in the hospital, when he's rushed to the emergency room, Dr. Mendoza is one of the team of emergency room doctors, trauma doctors, who first received the defendant. It's the first few minutes. What she's pointing to are later interactions with the defendant by other individuals. I am not contesting those.
And let me ask you, did the motion specifically say medical records?
No, it talked about any statements or records.
Okay. So Mendoza, what's Mendoza going to say about where law enforcement was when she asked him?
To be clear, I don't think anybody specifically asked her that in the deposition because it was not an issue at the time we conducted the deposition. I believe that she will say the point that matters, and I think Your Honor has already keyed onto it, this is a Fifth Amendment issue, and the Fifth Amendment is protection against the government's action, not layperson's action. If there was an allegation that HCSO had gone over to Dr. Mendoza and said, we need you to ask the defendant what happened, I would be dead in the water. I would not even stand before Your Honor and ask you.
That's good.
So I think that this is more akin to people talking on the jail phone calls. Clearly law enforcement is listening. We have the benefit of we can listen anytime we want. But I'm the state, HCSO is the state, any governmental agent is listening and can listen to a jail phone call. If the defendant was on the phone and someone called him and asked him a question and he answered, it would certainly be admissible because that's not government action asking him. If it's his brother or his cousin or his girlfriend, that is completely admissible. By the same token, if the witness was on the phone saying, you stupid SOB, why did you do this? And the defendant is not saying anything, it is my position that that would be admissible as well, particularly in a case where I believe the defense is at least headed in the direction of suggesting the defendant is not the one who committed this crime. I would point to all the questions that have to do with the accessibility to the neighborhood, whether the people could have gone through the cow pasture, where they could have crossed the culvert, whether or not they could have taken the walking trail, all of the things that suggest that this area is accessible to lots of people who could have easily come in and gone out and committed this crime. I would also point to the questions the defense has asked repeatedly of questions of witnesses that said, well, you got blood on your hands too, and you were just rendering aid. I think that all of those questions point to potential arguments the defense may make in terms of a defense.
But what does his refusal to respond to the medical personnel, what's your theory as to what that proves?
Well, if it was a self-defense case, so one of the things I'm going to argue, I can already tell you I'm going to argue, is that from 12:30, when the victim is found, until 5:15, when the defendant is found, we have gone out of our way to point out the fact that there are multiple police officers, multiple sheriff's deputies, sitting on the roadside in what is a dark area with red and blue lights active that you could not miss. I'm also going to point out the fact that there's a bloodhound, another dog, a helicopter, multiple deputies all walking around the area, and at no point is the defendant yelling, help me, I've been attacked, help me. Nothing. Nothing a person might reasonably do if they were the victim of an attack. There's no effort to go get law enforcement help.
Okay, but tie that into the doctor asking him a question. I don't know
So
what
if
question
the
he doesn't ask.
defendant wanted to suggest he acted in self-defense, which I've not heard them say, I concede, they have not said, I would reasonably expect, just like a person would run to the police if they were the victim of an attack, when a doctor would ask them what happened, they would say, I was attacked. I was attacked and I was stabbed in the neck. Right? Or if they asked them, a person, a sort of everyday lay person would say something like, it wasn't me, I didn't do it, I was attacked. Right? I think the failure to say those things is an indication that the defendant is the culprit.
But we don't get there until and unless there's a self-defense.
I disagree. I still have to prove identity. If it was self-defense, I think it's really easy. But even if it's not self-defense, right? Again, if I go back to the example that I gave, defendant is on the jail phone call. He gets a call from some person in his life that he's talking to on the jail phone call, a girlfriend, for example, right? And the girlfriend is saying, everybody in the neighborhood said you did it. What the hell? What did you do? And he says nothing. He doesn't say, baby, I didn't do it. Maybe it wasn't me. Maybe they got it all wrong. I'm the victim. I think that that would be admissible. It is clear that law enforcement would effectively be in a position to hear it.
Do you have a case that even remotely suggests that?
I
That
do
you
not,
can
because
cite me to?
I certainly don't have a case of a defendant in a hospital, but I think that there are situations.
The jail or whatever, all those scenarios, those hypotheticals.
Well, that's
you just
that's
gave
just
me.
the general adoptive admission case law, where a person says something and the defendant says nothing in return, right? If you had two defendants who had robbed a bank,
I see
right?
that with
You have
law
two defendants who
enforcement.
rob a bank. They come back and they're talking to one of their girlfriends. They're like, "Yeah, me and Larry just robbed the bank," and Larry's standing right there and doesn't say anything. That's classic adoptive admission.
Judge,
Yes.
remaining silent is not an adoptive admission when you are in custody. It would be a violation of his right to remain silent for them to even hint that him remaining silent in the custody of law enforcement was somehow an admission. There's no case because it's such an axiomatic point of law. You cannot comment on the defendant's right to remain silent. You cannot have officers who are at the bedside, as reflected in the very records they're trying to use to get this in, who are refusing to leave, which indicates, obviously, that the officers the entire time are there. Because if they're refusing to leave and outright telling a doctor who's saying, I need you to go so I can find out what happened, and they're saying, I'm not leaving, he's in custody, that tells you the entire time at that hospital, he was in custody.
I don't think Mr. Diaz, you're not
I'm not contesting he's in
contested
custody.
he's in custody.
But custodial interrogation is the standard. That's the standard. And interrogation means interrogation by the state.
Or doing anything that would be considered something that is forcing the defendant or trying to get him to speak.
At the
and then standing
direction
there.
of law enforcement, though. Not if law enforcement is. What if it was a cellmate that they were trying to introduce evidence that had questioned him or asked him questions and he didn't respond? What would you wouldn't object that it's a violation of his right to remain silent?
Absolutely, because
If
they're
a cellmate questioned him?
If their
No.
suggestion, yes, if their suggestion is that by not responding, he's somehow making an adoptive admission.
The Fifth
that's-
Amendment applies to a questioning by one's cellmate?
It
Who
depends
doesn't?
on the circumstances.
Well, yeah, at
If
the
police are
direction,
standing right
at the
outside-
direction of the government, but the Fifth Amendment it applies to government action. Can we at least start there? The Fifth Amendment applies to government action
or any action by the police that are putting somebody
at the direction
in a
of.
position,
Absolutely, at the direction of.
or putting him in a position where his silence is somehow being indicative of their claim that it's somehow an admission. The officer's action in this case is refusing to leave when the medical doctors are saying, we need this information to treat him. He can't be held accountable for remaining silent in the presence of law enforcement when he has every right to do so, because if he doesn't, they're going to use that against him.
Well, if he's in a jail cell at the direction of law enforcement, puts him in a jail cell, and another inmate in the jail starts interrogating him, asking him questions, and he remains silent, are you telling me the Fifth Amendment would prohibit that
if the officers are standing outside refusing to leave and he's somehow bleeding and trying to get help and that cellmate is the only way to get him help, who knows? Perhaps. That's exactly what's happening here. He can't get medical treatment without those officers being there hearing everything that he says.
Do we know what the question is that the doctor
Can we
asked
just
him?
stop for a second? She just said the defendant can't get medical treatment if he doesn't answer, and Dr. Mendoza has already been deposed and said specifically, I'm asking him this so I know how to treat him. That's exactly the reason she's asking him.
What is she asking him?
She's asking him what happened. I'll try to find the deposition. Mr. Dirks may have it handy. I don't know if he has it with him. I didn't bring the deposition itself.
And he refused to say what happened, and you want to elicit that.
I want to elicit that what I believe she said, and we can find the quote if you want. She said, he looked me in the eye, I asked him, he turned, he looked away, and he never answered me. Which is why I have also clarified that the defendant could talk.
I got you on that.
And Judge, if they're asking for a revisit of this, I understand perhaps it couldn't have been anticipated that Judge Williams wouldn't be here, but you had said that would be heard in front of him because our motion to reconsider was to be heard in front of him. If they're asking to now revisit that again in front of you, I am going to ask to revisit the issue about the medical records.
Judge,
those medical records,
Let her finish.
and them trying to get in the statements that there is no reliability to show that Mr. Terry said, and trying to use that as a statement for purpose of medical diagnosis and treatment is going to end up being the reversible error that sends this case back. So if they're having a revisit on a very similar issue, we should get to revisit that issue as well.
they did get to revisit it. They got to revisit it Monday morning.
And-
I asked to revisit it. You told me we were going to take it to Williams. I mentioned it to Williams Monday morning. He said he didn't know anything about it. Apparently he sensed out a conversation with you to at least tell you he's not available. I still haven't had
I haven't talked to him. I know that he did something. Well, I know that he's out.
But whatever. The point is, I haven't had my rehearing. I'm still asking to have the rehearing when Dr. Mendoza is available. It's disingenuous to say they haven't had a rehearing.
I didn't say we haven't had a rehearing.
You want to rehear it.
I said they
Rehear.
were told to have their rehearing in front of the same judge who made the ruling on the similar issue. They chose not to do that on Monday. I brought it up Monday morning because they didn't. And Judge Williams said, I hadn't heard anything about that, and counsel said, Judge, my understanding was you were going to come up and hear it with Judge Sabella when Judge Mendoza was here. They didn't ask
Dr. Mendoza.
I'm sorry, Dr. Mendoza would be here. They didn't ask for Judge Williams to hear that on Monday afternoon, Tuesday morning. Now all of a sudden they're asking you to rehear it. I'm fine if we have all of the issues about the similar items. We're talking about statements in the medical records. We're talking about statements to doctors. We're talking about the same things heard by the same judge.
As of right now, the statements in the medical records that Judge Williams has ruled twice are coming in are statements related to self-inflicted, I believe. Is that correct?
That's correct.
That's correct. There's a claimed statement in the records, despite 24 doctors and dozens of police officers saying that Mr. Terry would never answer questions when he was asked what happened. There is one statement in the medical records that gets repeated over and over and over in the records that says he says they were self-inflicted.
All right. Let me just ask Mr. Diaz, what did Judge Williams, I don't want to say I wasn't listening to you the other day, but since I said I was sending this back, I said Judge Williams can do all of it since he did it the first time. But you had indicated that Judge Williams made some representation that was something, did he rule or did he refuse to rule and say that that's something that needs to be taken up in front of me? That's what I'm unclear on. You may have said that the other day, and I just missed it.
Judge, I'm trying to find the email. I don't remember if I saved it on my computer already or if I still have it in my email, but I have the audio.
Of Judge
Williams. I
Okay.
asked him, and he said, you can take that up with Judge Sabella.
So he did not rule.
No.
Well, he did. He did. He made a ruling that said the statements are out, and then I said, Judge, does that apply to live testimony too?
So what made you think, because when I asked before if the motion said just medical records and it wasn't, what made you think that his ruling, why was there the door open to ask, does that apply to live testimony too, if his ruling was regarding medical records and any statements?
Well, again, I wish I had the audio in the second play for you, and I might be able to find it if you give me a moment, but he said something to the effect of, it's unclear from the medical records. And so I wanted clarification. And if Judge Williams had said, yes, it applies to everything, no matter how it was said, then I understand that's the ruling. I have to live with it. But because he said, take it up with you, I initially tried to broach it with you. Then you said, no, it's going to be Judge Williams.
Sounds like we're passing the ball back and forth.
I got it. You made a very specific declaration that Judge Williams was going to come up here, sit in your chair, and hear the hearing. Which,
and that's because he heard all the pretrial motions.
I honestly don't care whether it's you or Judge Williams. I really don't. I mean, I just want to get an answer so I know what to plan for.
Mm-hmm.
Okay? So if it can be Judge Williams because he is available, then fine. I am not judge shopping.
All right, I'll check because he was the original judge, and I will check. I do not know, as I sit here right now, the answer to that. I think it'll be a lot quicker for him because he knows what got him up to the point, and then whatever new wants to be presented, I think it's quicker. But if he's unavailable, that may be a little different. I'm not ruling on whether you can re-argue the notes. Maybe not. I'm not saying no. I don't know yet whether Judge Williams is going to be able to, I guess, rehear with additional evidence, which is the doctor's testimony, whether that meant live witnesses or just notes. So let's table that for a moment. What about the other issue? Was there another issue from the defense, or was
No,
it stated?
they wanted a ruling, or to know if you had made a ruling on the Williams rule.
Well, I reserved, but part of my reservation was I didn't know the other part of what it was being sought to, what was the purpose. There's a list of reasons, and Mr. Diaz, you would agree, you didn't give me a reason before.
I gave you multiple reasons. I gave you multiple bases under the similar fact evidence rule for which it could be admitted. I mentioned identity, I mentioned intent, I mentioned absence of mistake, and I mentioned to rebut a defense. Now, some of those sort of overlap. For example, if the defense was the defendant was acting in the heat of passion, right, that's also sort of an intent question. If the defense was the defendant is acting in self-defense, that's also an intent question, right? So, like, it's under an umbrella, and it's difficult. I could sit here and try and hypothesize a variety of defenses that could occur. As we sit here right now, I have not heard the defense say self-defense, but of course that can change at any moment. But I'm proceeding at the moment under the fact that this is not a self-defense case, okay? If it is, I think the equation changes radically. But I think that what I've heard so far is I've heard questions suggesting the defendant is not the one who committed the crime, so identity is certainly an issue, okay? And I don't.
What were the other suggestions?
There's the absence of mistake, which is also, again, sort of tied to intent, right? If the defendant, and I don't know that he will, I'm just saying hypothetically, if the defendant tried to say something like, I never meant to slice her throat, it happened accidentally, that he was arguing, for example, for a manslaughter, that would be, I killed her accidentally, right? It was a mistake. But that is also an intent question inherently, because I'm arguing it's premeditation and they're arguing it's not premeditated, it's manslaughter, right?
And I apologize, that's what I remembered. I thought most of your argument was, if they do this, then it's for this purpose. If they do this, then it's for this purpose. But so far...
And Judge, I have repeatedly, and I respect the fact, I'm not trying to in any way suggest they're under any obligation to tell me what their defense is, but it is difficult to answer the question that you're asking me when I don't know what it is I'm specifically rebutting. If the defendant says it's self-defense, identity is not the issue in the case anymore, right? The defendant is saying, I did it,
but it's justified.
It's justified. That is an intent question. If the defendant says, I didn't do it, it was some other individual who came from the cow pasture.
Then identity is the issue.
Then identity is the issue. If the defendant says, it started out as a stupid argument, it escalated, and I killed her by accident, right? Then
That's
it's
a
both
lack
an
of-
intent, and so like, I don't know. And I am not happy to have to ask Your Honor to make a decision right now, because I imagine Your Honor would love to know whether or not the defendant's going to testify, because that might radically change your evaluation, because you might hear what he has to say.
When do you intend to use it? After we know that and they testify and
Well,
your
Judge,
rebuttal
unfortunately,
case?
I don't think I'm going to be in that position, which is why I was trying to sort of, that's why when I started this, if you notice, I was trying to talk about scheduling, because what happens on Thursday can make a big difference. If I have the entire weekend to get people here, it's no problem. My witnesses have to come from Michigan. It's Tuesday. At my current schedule, I am looking to rest on Thursday by lunchtime. Okay? I certainly think that there is a basis on identity alone
To put it in on your case in chief.
to put it in on my case in chief.
But a lot of those other issues would be in your rebuttal case, depending on what they do in their defense case.
Right, and so I'm just trying to get a heads up, because I don't want to get to Thursday at noon and now I'm like, Judge, what do you want me to do?
All right, so I mean, we've narrowed it down significantly. The only basis for you to legitimately argue at this point is for identity.
No, I've just said that, Judge.
But they haven't.
Judge, I still have to prove intent.
Intent. Okay,
I
intent
still
and
have to prove
identity.
intent. Like, there's 3 elements to murder. One is the victim's dead. The state and defense have stipulated. So it's only who did it and what was their intent.
Okay. Well, tell me how the previous incident proves intent. How are you going to argue if I allow the testimony of the previous Michigan incident? How does that prove intent?
Well, I think it separates the issue of manslaughter, right? That this is an intentional act, not an accident, effectively. Because again, accident and intent are kind of the same thing for this particular case. I think it also separates the notion of whether or not this is second-degree murder versus first-degree murder. The fact that the defendant has in a previous case had an argument with a girlfriend, gone to a butcher block, pulled a knife out of a butcher block, come back and intentionally stabbed his girlfriend in the throat during a domestic dispute, because that's what Michelle Rogers said. She said he went and got the knife, and the first thing he did was he came back and he stabbed me in the throat. And then the fight continued to linger. It goes outside the home. He's continued to attack her multiple times. He's stabbing her more than one time. All of these things, I think, go to premeditation. And so I do think the analysis is obviously slightly different, whether Your Honor's looking at it as an identity case, an identity situation, or whether you're looking at it as an intent versus accident mistake situation. But I think at least, I'm not suggesting it's planned. I'm not suggesting it was prepared. I don't think knowledge of the crime is an issue, okay? It's not opportunity. We can start the list of all of the things that are listed under the rule and start crossing them out. But we're always going to have intent, we're always going to have identity, we're always going to some degree, in a murder case, have the issue of accident or mistake, and then there's always the catch-all, which thus far I've not heard a specific defense like self-defense, but there's always that one still lingering out there.
Let me ask you though, if I let it in your case in chief, and then we find out in their case that it's a self-defense case, then wasn't I wrong for letting it in for identity and intent?
Well, no. I think intent is the opposite of self-defense. What was your intent when you did it? Did you shoot this person and kill them in self-defense? Or did you shoot this person and kill them basically unjustified? Because that's what self-defense really is. Self-defense is a question of what is in the mind of the defendant at the time that they commit the crime. Do they do it because they are in fear of the imminent threat of a forcible felony? Or do they do it because they're intending to kill someone and there's no fear that plays into it? That's an intent question. Self-defense is all day long a question of intent. The jury's going to have to ultimately decide what is in the mind of the defendant.
Judge, how do we get away from Balzort? Balzort was very clear, for the record, that 75-7-3-380, Florida 2nd District Court of Appeals case from 2011. That said, you have to not only have a strikingly similar offense,
which we don't, which we went through at the Williams Rule hearing about why this case is not strikingly similar to the Michigan case, but you also have to have something unique about the two cases that somehow are like a fingerprint of the defendant. And the factual scenario in Balzort is directly analogous to the factual scenario here. There you had two domestic violence cases. The first one, the victim survived. The second one, the victim did not. You had both of them being by the same instrument, his hands, strangulation. Nothing was unique about that, and the trial court let in both of that, the evidence about both, the actual trial that was being tried and the evidence about the prior case where the victim survived, claiming it was under the guise of Williams Rule. And the Second District Court of Appeals said no and reversed it and said not only were they not strikingly similar because the first victim survived and the second didn't, but it also was nothing unique that would have allowed for those instances to be something akin to a fingerprint. There is nothing about the Michigan case here that in any way is some sort of fingerprint that proves Matthew Terry committed the case at bar. And under Balzort, that would be reversible error for the state to be able to use the Michigan case somehow to claim that we know Matthew Terry's the perpetrator here.
You make good points, and I don't want to make a mistake on this. This is a very important issue. Mr. Diaz, as to your response on Balzort and the uniqueness.
Okay, so I want you to listen to what defense said, because she's absolutely correct in what she said, but you have to listen to it carefully. It's to prove the defendant did it. That's identity, right? Not intent. Okay? I know that for identity, it has to be strikingly similar. Although I contend that there is a difference between the way Ms. Perry describes it as a fingerprint, which is unique, is not the same standard as similar. It's not identical evidence. It's similar evidence. It has to be similar, and I return to the analogy I gave you.
Yeah, say it again. I remember it.
You got to turn the dial, and Your Honor's going to decide at some point the dial has been turned, whether it's 7 or 8 or whatever the number is you put, that's where it became similar. However, while I concede that the defense is correct as to what Balzort says, as I was sitting here, I opened Professor Earhart. And Professor Earhart is very kind to break up Williams Rule evidence, both for issues of intent, that, for example, starts on page 301 of the 2022 edition, is a separate section from intent, which starts on page 307.
Wait, I think you might have misspoke. I think you said intent. I think you said intent twice. I could be wrong.
Intent and then an identity. Identity starts on 301, and 307 starts intent. And if you look at intent, and I would ask Your Honor to read the case because I hate not having a case here to hand you, but I do not, you will see that Professor Earhart writes that evidence is admissible under section 90.402 sub 2 when it is probative to show intent, which is generally an ultimate issue in the case. Offering the evidence to prove intent is similar to offering it for some other permissible Williams Rule purposes, such as motive and plan, which form the basis of inferring intent. If the collateral acts are relevant to show intent, they are admissible even though they are not similar.
What case is it cited?
Well, so that's footnote number 3. And if you go into footnote number 3, and I was here reading all the cases, you come to Vincent versus State, 885, Southern 2nd, 963, and then it quotes to pages 965 through 966. It's a Florida 3rd DCA case out of 2004. The summary written by Professor Earhart is, where the defendant was charged with the stabbing death of her boyfriend, no abuse of discretion to admit evidence that the defendant had stabbed a previous boyfriend to prove that the stabbing was intentional and not occurred as a result of the victim accidentally stabbing himself as claimed by the defendant. Now, I get it. In that case, the defendant has made a specific accusation that the victim stabbed himself. However, when you read the case of Vincent, the court does an analysis. The defense contends that the evidence of the stabbing of Junior Charles was not similar enough to the charged crime to justify its introduction into evidence. The state replies, and we agree that there were multiple points of similarity between the prior stabbing and the current stabbing. The relationship between the defendant and the victim was the same, girlfriend and boyfriend. Each incident occurred in the home. Each incident occurred during a domestic argument, and each incident involved a knife. Both victims were stabbed in exactly the same location, which in this case was the chest, not the neck. That's 5. They also say in both incidents there was a completed act of stabbing. That's 6. And in both incidents the defendant was remorseful after the stabbing. And I concede I don't have that. Okay? But that's 6 things out of 7 that they listed that are exactly the same here. It's a boyfriend-girlfriend situation. It's a domestic situation. It starts in a home. It involves a knife. It is a stabbing in exactly the same place. And it's a completed act of a stabbing.
Okay, that's why each of you are such good attorneys. I hear Miss Perry cite Balsworth, and I say, wow, she's got a really good point. Then you cite Vincent, and I say, wow, he's got a really good point. But I made you respond to her Balsworth. You responded to it with Earhart and Vincent.
And
let me hear Miss Perry respond to Vincent.
And just so your Honor is aware, Balsworth is cited by Professor Earhart. Balsworth is cited in the identity section. He's not cited when we get to the intent section.
I got you.
Can I have the sites?
To Vincent?
Yes.
Sure.
885 Southern 2nd 993. Is that correct?
Vincent was, sorry, give me 1 second. Let me find it again. 885 Southern 2nd 963.
Oops. Dyslexic.
I did the same thing with Balsworth. It's 830, not 380.
Uh-oh. Did I write that down? Well, I have Balsworth. I have all. I'm gonna read these cases tonight. But I want to hear your response. But you know what? Go ahead. You want to take? I'm gonna rule in the morning, Mr. Diaz.
Yeah, no, that's fine, Your Honor.
I want to read Vincent.
I was just going to ask you to give me a ruling on Wednesday morning. That would give me time to get people here from Thursday if it's on.
That's my intention. I will rule tomorrow morning before 9 o'clock. I will give Ms. Perry an opportunity to review Vincent and to make a last argument on the difference between identity and intent and distinguish Vincent. Miss Bradley, you have something?
Judge, just as far as we're getting into the area of intent, obviously it's a different ball game if there's some kind of self-defense claim or an affirmative accident type of claim or things of that nature. You know, a lot of the case law that Mr. Diaz is bringing up is someone who is saying that something happened and it was an accident.
But intent is in the elements of first-degree murder.
Yes, but what I'm saying is there's a differentiation between those two things.
Two different types of intent?
I'm saying there's a difference between having to prove premeditation and having to negate an accident. That is two different things when you're looking at the case law, because that's where you're starting the slippery slope. As you're talking about turning a dial, it's turning a dial to using this evidence for nothing more than propensity.
I hear you,
and
but
that's where that becomes very important.
Understand, but as you stand here, because I don't know the facts of Vincent, other than it was a girlfriend-boyfriend, but do you know whether it was a self-defense claim in Vincent?
No, I don't, but I know that Mr. Diaz talked about the defendant saying it was an accident.
That's correct. She claimed it was an accident. She claimed that the defendant walked into the knife.
That's saying I did it and it was an accident. That's very different than having to prove premeditation.
Okay.
And I don't mean to throw a third voice into this from the defense.
But you are.
Yes, I am. If in a theft case, every time there was a prior, is that to say that the state has to prove intent in practically every crime? Right? Practically every crime requires some intent element. Is that to say that somebody's charged with a second theft and they don't give any defense at all, that the state can bring in Williams' role on that prior theft? Simply
And
because
it was a very, very similar theft, then maybe.
Aren't they all? I mean, if it's just shoplifting, are they able to bring in Williams Rule just because somebody's committed theft before? That's not the purpose of the rule. Intent necessarily requires there to be some sort of theory of defense that the state is resting on that causes that intent to be relevant.
It would have to be similar facts,
It has to be relevant.
not just similar crimes.
I believe that the proper term is strikingly similar. And so also the other problem that we run into here is that we had filed a motion to strike the state's notice, and we had fought to keep this evidence out. And all of that was denied, and I think the court reserved ruling. And we have not voir dired this jury on Williams Rule. We have not even brought that prospect up because of the fact that we don't want to prejudice Mr. Terry, and we don't know how this jury would have viewed any sort of evidence of a prior act in its case in chief. Now, the jury doesn't know that Mr. Terry has a prior violent felony, but if, in order to determine whether or not this jury would have been predisposed to finding him guilty if there had been Williams Rule information introduced, and we could have crossed that bridge with the jury, we could have brought up that topic. We haven't done that.
You knew it was a possibility.
Well, exactly. But that's the problem with reserving ruling on Williams Rule. That's the problem. And we had asked for a ruling. They have not established relevance. In other words, what they're doing is they're taking relevance day by day. The notice should give the defense some idea of what the relevance is. In other words, before we pick a jury, the state has practically rested its case. And we still don't know the court's position on Williams Rule, which means the state still has no idea what the relevance is. They can't establish relevance except for the fact that it's strikingly similar. They don't know what our defense is. We're not obligated to tell them. Mr. Terry hasn't given a statement to the police, which would give them some idea of what his frame of mind might be in terms of his own defense. Nothing. Zero.
Well, I think that their position now is that it's relevant to prove intent. Is that correct?
Intent and identity and accident or mistake, but again, I think accident or mistake go to intent at the end of the day.
Let's talk about what intent is then. You are trying to make the argument that basically anytime you have a domestic with any partner, that shows an intent later to somehow batter a different partner under different circumstances for a different argument just because you had a prior domestic. That means
different circumstances. It's same circumstances, jealousy, same weapon, knife, same so strikingly similar facts.
They are not strikingly similar.
Who gets to decide that?
You do, but we had a hearing where a list of differences was outlined for the court. It's not just similar, it's strikingly similar. And the striking similarity doesn't exist here. We have somebody who specifically, frankly, is mentioned in Balzort as being a main difference, and that is Michelle Rogers, who survived. Balzort talks about that fact alone making the two cases not strikingly similar.
You would agree, though, that the same strikingly similar test would be the one that the Vincent court used, maybe for a different reason, for intent in not walking into the knife, but they still had to satisfy the strikingly similar in Vincent, correct? I haven't read, and here's the thing. We're wasting a lot of time here because I haven't read it, okay? I will be much better prepared tomorrow when I read Vincent and I come in, and I'm not telling you I'm going to come in with an opinion, made up. I'm going to give you the opportunity because although you've looked at Vincent and you've made some good arguments as possible distinctions on Vincent and looking at the differences in types of intent, I will allow you to be heard in the morning. But it's a waste right now because I haven't read Vincent. So let's do that in the morning. We'll come in at 8:45. I know that I told the jury 9, but if it takes a little longer and we have to, actually, let's make it 8:30 for us in here. We can.
Very quickly, I apologize. There was no allegation of jealousy in the Michelle Rogers case.
That was a argument after drinking. You may recall we going to multiple bars. You may also recall that Ms. Rogers, when she testified, indicated that she couldn't even remember what started the argument.
I addressed this issue in the original Williams Rule motion. I conceded that this was the state's position, that it was a case of jealousy here, and that he did not say he was jealous in the other case, but I went to great pains to point out to the court that ultimately what the issue is, it's insecurity in the relationship. The defendant said, "You don't love me." It was the insecurity.
Okay. I misspoke. I apologize. All right. So, 2 issues for tomorrow morning.
Well, and I'd like to at some point confirm with Your Honor what I started with, which was for you to agree that I can leave my last 2 witnesses for Thursday.
Absolutely.
Okay.
Absolutely.
Because Ms. Troutman and Ms. Cox, I think, will be long, and I don't want them sitting out here and then we can't get to them on Wednesday afternoon.
Absolutely. Well, let me ask you this. Depending on how I rule tomorrow morning, when can you get those other witnesses here from Michigan?
Well, if you tell me tomorrow at 9 o'clock, I'm going to call them immediately, and I'm going to try and put them on a plane the same day to have them here for Thursday morning. So,
And is it the 2 that testified?
I will bring the victim and the detective. That's who I will bring. And they are standing by. I spoke to them on Monday night because I'm sure they're going to call me again tonight because the victim has a child, and so I need to give her advance notice. Hey, you got to get your child to your friend so you can come down.
All right. Well, I'll make a decision in the morning. No question about that.
Just scheduling wise, we went through 12 witnesses today. They're suggesting we're only going to go through 7 tomorrow. I don't know.
If we
how
break
long-
early, we break early. If they're
Well,
going to
that's-
finish on Thursday.
That's why I brought it up, because I was trying to point out I don't really know, since I cannot predict what the defense will do, and they're certainly not under any obligation to tell me, but I don't know how long the medical examiner, the actual autopsy doctor will be. I don't know how contested Dr. Devers will be. I don't know how long Robert Durr and Brandon Douglas will
and
be.
they're all tomorrow.
And they're all tomorrow. And then there's the lead detective, and I can still bring Detective Watson. And so
I
don't-
assure you it'll take up a majority of the day tomorrow.
Plus, we still
I
have
don't see us break in at 3 o'clock tomorrow or before. I know you may not have a whole lot across, but we'll see.
I mean, if we burn through 6 out of 7 witnesses at noon, I will call Ms. Troutman and tell her to come down. I will do that. I just don't think that we are going to be.
I mean, I'm flexible with you all too. If they finish up, I'm not going to, penalize you because you don't have a witness here. I'm very flexible. Very flexible.
No, I'm concerned that we would actually get through all 9 that are left tomorrow if they had them here. Because that's why I said 7 when we went through 12 today. We are probably in a position, I would think, but that has to be something they decide based on what they're doing with their directs. But I think we are probably in a position where the witnesses would be done tomorrow. Just looking at how we went through today.
Well, but doesn't it depend on? I mean, they might add 2 witnesses.
Well,
I mean, I'm not. There might be. That's a possibility that's on the table. I understand they want to do Cox and Troutman last, but can you do them before?
I cannot do Anna Cox before Alyssa Troutman because she needs the DNA evidence.
No. Before the 2 from Michigan.
Oh, if the 2 from Michigan comes, I would put them on. So again, that's why I'm trying to be as upfront as possible. My intention is to do everyone that's left except for Anna Cox and Alyssa Troutman on Thursday morning. If Your Honor allows the Williams rule evidence, I guess I could do it out of order, although I would prefer to do Ms. Troutman.
But they won't be here tomorrow.
Not tomorrow, no. They would be Thursday morning, which is why I'm saying I wasn't in a rush. Well, first off, setting aside the Williams rule evidence, I was going to do Troutman and Cox tomorrow because I have concerns that we cannot get to both of them before the end of Wednesday. I think that by the time we do Dr. Devers, Dr. Perkins, Brandon Douglas, Robert Durr.
Is it possible to have them on standby? I think what Ms. Perry is suggesting that if we fly through witnesses, we may be in a position to get to do Troutman and Cox tomorrow.
Yes, I can,
late afternoon.
I can have Ms. Troutman standing by, and if we have magically flown through 5 witnesses by lunchtime, then I'll tell her to be ready.
Let's do that. Let's do that just in an abundance of caution. And I think what I'm also hearing you say is that if on tomorrow morning I'm to say the Williams rule witnesses can testify, that they could testify Thursday morning. They could fly in.
I'm just asking for at least 24 hours get them in here.
But it's all right putting them on after Trotman and Cox.
Yeah, that's fine. I don't.
Okay.
It's not. I'm not particular about the order. I just need enough time to get them here.
All right, tomorrow morning, 8:30. I'm going to read Vincent, and I'll give the defense an opportunity to respond on the Williams rule issue, and then I'll rule on the other issue as well. Let you know. Anything else?
Not from the defense.
All right. Well, and look, it's 5 o'clock, so anyone who's here who hasn't voted should have plenty of time to get to the polls. Was there anything else from the state?
The only thing that I have is my view of the experts that are coming tomorrow. We're not going to be flying through them like we did.
Okay.
Just
Well,
to
we'll
let you
see at
know.
noon. We'll see at noon. We'll have the opportunity to make a call midday.
Yes, sir.
All right.
Thank you.
Thank you all. Have a nice evening.